Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On the show, I'm able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do feel free to get in touch with us here live in the studios. Two ways to get in touch. To speak to me live, you can ring on the landline number which appears at the bottom of the screen. Alternatively, another very popular way of getting in touch is to ring us on, to send us a message on the mobile number which is also there at the bottom of the screen. To speak to me live, it's the landline number, and to send me a message, a text message, a WhatsApp message, please do so on the mobile number which is at the bottom of the screen. The way of getting in touch by way of mobile number by sending us a message is a very popular method, and even before we've come on the show today, we've had a number of messages coming in. So please do continue to send your messages in with your legal questions. But as always, it's always good to hear from you. So please do, if you have a questions, feel free to pick up the phone and speak to me live as well. A couple of very minor matters before we get going. On a live show, sometimes it's not possible to take very detailed information from callers who call in, especially where the matter is complex. Sometimes it transpires that I need to look at your documents before I can advise you properly. You might have had a refusal letter, it's an immigration matter, you've received a refusal letter, or it might be some other document that you've received that you want me to look at. So if the matter is quite complex or I need to look at documents before I can advise you properly, then I will ask you to leave your number with the control room. Then I'll have that more thorough discussion with you off air, and if need be, I'll make arrangements for you to send your documents in so I can have a look at your documents and then have a proper discussion with you. And it is the free legal advice show. This is a service that we provide here on British Muslim TV free of charge. So even if you need to run a query by us after the show, if I need to look at your documents, it's not a problem. So on the show, we get numerous questions on immigration law, which is fantastic. 80-90% of the queries coming in relate to immigration law matters, which is fantastic. Please do continue to send your questions in. But as I said at the outset, I am able to deal with other areas of law as well, whether it's family law, property law matters, personal injury law matters, criminal law matters. So whatever your legal questions are, please do feel free to get in touch, and I will try and guide you as best as I can. Now, just before we've come on, we've had a number of questions coming in on that mobile number we have appearing at the bottom of the screen. So let's start looking at some of those questions that have been coming in already. Let me read the first question out and then let's see what the best advice is for our viewer who has texted in. So the first question for the day on WhatsApp is as follows. So, hello, Assalamu alaikum. My inquiry is regarding my mum's visa refusal to the United Kingdom. Visa has been refused on 2 occasions. Her refusal is based on her being alone in India and her 4 children living in the United Kingdom. The Home Office refused her because they believe she won't return to India. So, question regarding a visit visa. We will look at this in greater detail, but we do have a caller who's been waiting for a while to come on. So let me just take the call, then I will return to this question after that. Hello, Assalamu alaikum.
जी वालेकुम सलाम जी 2 सवाल है हमारे
जी भाई जी।
पहला सवाल ये है कि अगर लड़का पाकिस्तान से स्टूडेंट आया वो यूनिवर्सिटी के में कोर्स के लिए, तो अगर वो यहाँ से शादी कर ले ब्रिटिश लड़की से, तो क्या उसे पाकिस्तान वापस जाना पड़ेगा, नॉर्मल प्रोसीजर, या यहाँ से स्विच हो सकता है वो?
जी, यहाँ से वो वीज़ा अप्लाई कर सकता है, क्योंकि उसके पास तो स्टूडेंट वीज़ा है ना, तो स्टूडेंट वीज़ा में स्विच कर सकते हैं, स्पाउस वीज़ा में वापस पाकिस्तान जाने की ज़रूरत नहीं है। तो
एक और दूसरा सवाल है, जरा वो टेक्निकल सवाल है।
कोई बात नहीं जी।
وہ سوال یہ ہے کہ ایک لڑکا ہمارا آیا ہوا ہے, بیٹی کی شادی کی ہے پاکستان سے, لڑکا پاکستان سے آیا ہوا ہے,
جی
تو اسے 2-3 سال ہو گئے ہیں, 2 سال ہو گئے ہیں.
جی
تو کچھ لڑکے کی عادت جو ہے نا وہ ہمیں کچھ ڈاؤٹ پیدا ہو رہا ہے.
جی
تو ظاہر ہے ہماری بچی ہے ان کے گھر میں,
جی
تو ہم شادی کو توڑنا تو نہیں چاہتے,
جی
لیکن لڑکی کی تنخواہ جو ہے نا وہ کافی زیادہ ہے, تو اس کی 5 سال بعد انڈیفینٹ اسٹے بنتی ہے
جی
لا بائی لا,
جی
کوئی پرابلم نہیں ہے اس میں.
جی
لیکن ہم اسے 10 سال میں لے کر جانا چاہتے ہیں کہ ایسا نہ ہو کہ 5 سال میں
انڈیفینیٹلی
نیشنلٹی لے لے
جی
اور وہ بس چلتا بنے.
جی.
تو ہم 10 سال پر اسے کیسے لے کر جا سکتے ہیں؟
اس میں 2 راستے ہوتے ہیں 10 سال میں. ایک تو جب 5 سال کے بعد اپلائی کرتے ہیں نا, تو آپ اس کو بتا دو کہ سیٹلمنٹ کا فارم ہے وہ ہم نہیں کریں گے, ہم صرف ایکسٹینشن کا فارم ہی فل کریں گے. تو ایک تو آپ اس کو صاف بتا دو کہ جو سیٹلمنٹ کا فارم ڈفرینٹ ہوتا ہے وہ ہم کرنے کے لیے تیار نہیں ہے, صرف ہم ایکسٹینشن کا فارم ہی کریں گے. تو ایک آپشن یہ ہے کہ اس کو صاف بتا دو کہ ہم وہ ایکسٹینشن کا فارم کے لیے ہی ہم سگنیچر کنسنٹ دیں گے. ایک راستہ یہ ہے. سیکنڈ راستہ یہ ہے کہ اگر کوئی ریکوائرمنٹ ہے جو وہ فلفل نہیں کر سکتا, فار ایگزامپل جو فائنینشیل ریکوائرمنٹ ہے, انکم ٹھیک نہیں ہے, یا تو انگلش کے جو ٹیسٹ ہوتے ہیں B1 ٹیسٹ ان انگلش, لائف ان دی UK ٹیسٹ, اگر وہ پاس نہیں کرتا تو پھر اس کو وہ 10 سال والی روٹ میں وہ ڈال دیتے ہیں اگر بچے ہیں تو. سو ایک تو اس کو صاف بتا دو آپ کو ہم یہ کرنے والے ہیں. سیکنڈلی تو یہ سچویشن ہے کہ اگر جو ریکوائرمنٹس ہے اگر وہ فلفل نہیں کر سکتے تو پھر اس کو تو ویسے 10 سال میں جانا ہی پڑے گا اگر بچے ہو تو. یہ 2 آپشنز ہیں. اصل میں پرابلم کیا ہے ابھی کہ اگر آپ نے وہ سیٹلمنٹ کا فارم فل کیا, وہ بھی فی بھی پے کر دی, سیٹلمنٹ کی فارم بھی سائن کر دیا, اور سارے جو ریکوائرمنٹس ہیں وہ فلفل ہو جاتے ہیں, تو ہوم آفس والے تو پھر اس کو دے دیں گے کہ آپ نے سیٹلمنٹ کے لیے اپلائی کیا, آپ نے کنسنٹ بھی کر لیا, جو لڑکی ہے اس نے سائن بھی کر کے دے دی کہ میں کنسنٹ کرتی ہوں, تو پھر تو دے دیں گے نا. تو راستہ ایک ہے نا کہ سیٹلمنٹ کا فارم اپلائی ہی نہ کرو, بس اس کو بتا دو کہ ہم تو یہ کرنے کے لیے تیار ہیں, پھر بعد میں دیکھیں گے. ایک آپشن. یا تو سیکنڈ آپشن, اگر جو ریکوائرمنٹس ہے فائنینشیل ریکوائرمنٹس یا تو انگلش کی ریکوائرمنٹس, اگر وہ فلفل نہ کرے تو ہوم آفس اس کو 10 میں ہی ڈال دیں گے.
فار ایگزامپل ہم تنخواہ تھوڑی بتائیں کہ ہماری 15,000 تنخواہ بنتی ہے یا کام شارٹ کر دیں,
جی, تو آٹومیٹکلی اس کو ڈال دیں گے 10 سال میں. بچے ہیں اس میں, بچے ہیں یا نہیں ہے؟
نہیں بچے نہیں ہیں ابھی.
اصل میں اس میں تھوڑی سی رسکی ہے کہ اگر بچے نہیں ہے نا, اگر بچے نہیں ہے تو وہ 10 سال میں نہیں ڈالے. وہ یہ کر سکتے ہیں کہ وہ بالکل ریفیوز ہی کر سکتے ہیں اس میں. یہ جو 10 سال والا ہے نا وہ بچے میں دیتے ہیں. تھرڈ آپشن کیا ہے کہ اگر بچے نہیں ہیں تو اس میں جو فائنینشیل ریکوائرمنٹ ہے وہ فلفل کر دے, مگر انگلش کا جو ہے نا وہ کہے کہ ہم نے B1 پاس نہیں کیا یا لائف ان دا UK پاس نہیں کیا, اس لیے ہم کو ایکسٹینشن چاہیے. یہ تھوڑا سا مجھ کو تو لگتا ہے کہ بیسٹ آپشن یہ ہے, کیونکہ بچے نہیں ہیں یہاں. بیسٹ آپشن یہ ہے کہ اس کو بتا دے کہ لوگ یہ پرابلم ہے, ہم ایکسٹینشن میں جائیں گے.
تو اگر ایکسٹینشن والا فارم نہ بھریں, بچے بھی نہیں ہیں, تو پھر اسے واپس تو نہیں کریں گے وہ؟
اگر کچھ بھی نہ کرے تو
جی اگر بچے بھی نہیں ہیں
جی,
اور جو فارم ہے پرماننٹ اسٹے والا وہ جو بتا رہے ہیں وہ بھی فل نہ کریں گے, یہ ہم نہیں کرنے والے,
ہاں ہاں,
تو پھر اسے پاکستان واپس تو نہیں بھیجیں گے, وہ 10 سال کے روٹ پر ڈال دیں گے. نہیں,
اگر بچے نہیں ہے نا اور جو ریکوائرمنٹس جو ہے نا وہ فلفل نہیں ہو سکتی, تو پھر پرابلم ہے کہ اس کو اس کی ویزا بھی وہ فنش کر سکتے ہیں نا, کیونکہ وہ 10 سال والے ہیں نا. اس میں 3 آپشنز ہیں نا. ایک تو اس کو صاف بتا دے کہ ہم یہ کرنے والے ہیں اور سارے ریکوائرمنٹس فل کر لے, صرف وہ ایکسٹینشن کے لیے اپلائی کریں. سیکنڈ ہے کہ سارے ریکوائرمنٹس فلفل کرے ایکسیپٹ انگلش, اور کہے کہ ہم کو تو ایکسٹینشن چاہیے, تو وہ ایکسٹینشن دے دیں گے. اگر آپ نے سب ہی فلفل کر لیا اور سیٹلمنٹ کا فارم بھی فل کر لیا, تو اس کو سیٹلمنٹ دیں گے نا.
ٹھیک ہے.
اگر آپ نے رائٹ فارم فل کیا اور سارے ڈاکیومنٹس بھی جو دینے ہیں وہ دے دیے تو اس کو وہ انڈیفینٹ دیں گے نا. یہ پرابلم ہے نا اس میں.
ٹھیک ہے جی, تھینک یو.
جی, اس میں تھوڑا سا کیئرفل رہنا ہے بیکاز بچے نہیں ہے نا, اس لیے اس کا ایک طریقہ ہے کرنے کا, مگر اس میں تھوڑا سا کیئرفل رہنا پڑے گا کیونکہ پھر ڈینجر یہ ہے نا کہ اگر پراپر نہیں کیا نا تو ڈینجر یہ ہے کہ بالکل ہی اس کو ویزا نہ دے. یہ بچے نہیں ہے نا, اس لیے یہ رسک ہے, اس لیے یہ کر سکتے ہیں. آپ جو کہتے ہیں نا وہ کر سکتے ہیں مگر اس کو پراپر کرنا پڑے گا.
ٹھیک ہے.
ٹھیک ہے نا, ٹھیک ہے, چلو
تھینک یو جی.
جزاک اللہ, تھینک یو ویری مچ آپ کے کال کے لیے. Thank you very much indeed. Thank you. That was a question relating to where a spouse in the United Kingdom is potentially eligible for indefinite leave to remain after 5 years in the United Kingdom. But there are some problems within the marriage. And what was being considered is instead of the husband applying for indefinite leave to remain, whether there is a way of merely extending his visa. And the advice that I gave was, good, look, if you complete the settlement form and all the requirements are met and you consent to it as a wife, then the husband will be granted indefinite leave to remain. The way to ensure that only an extension is granted is to apply for an extension only. And that is really the way to do it. The final point I was making was you need to be careful, because if you get something wrong, as there are no children, if you get the process wrong, the Home Office could say that the husband has to return back to Pakistan. So you need to be careful about how you proceed in order to ensure that the husband remains with limited leave to remain. That brings us to our first break. Inshallah, we're going to be back in the next couple of minutes. We'll look at the WhatsApp questions then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, please call on the landline number which appears at the bottom of the screen. Alternatively, as always, you can send your messages in on the mobile number which is also there at the bottom of the screen. We've had a caller waiting for a while, so let's go to our next caller. Hello, assalamu alaikum.
السلام علیکم brother.
Ji walaikum assalam, brother. Thank you for calling.
ہاں جی بھائی, میرا ایک کویسچن ہے کہ اگر آپ آن لائن اپلائی کرنا چاہتے ہو ٹریول ڈاکومنٹس کے لیے,
جی جی,
تو کیا آپ کو اپنا بی آر پی کارڈ بھیجنا پڑے گا یا نہیں, اس کی صرف نمبر؟
وہ صرف نمبر مانگتے ہیں فارم میں.
اچھا, تو بی آر پی,
جی, وہ اوریجنل بی آر پی ابھی نہیں بھیجتے. وہ صرف آپ جب فل کریں گے نا تو اس میں کویشچن ہے کہ آپ کو بی آر پی ایشو کیا گیا ہے, اس کا نمبر کیا ہے, وہ مانگتے ہیں.
بس وہ بی آر پی وہ نہیں بھیجنا؟
نہیں بھیجتے نہیں ہیں, ابھی نہیں بھیجتے.
پکچر تو بھیجیں گے نا؟
جی,
پکچر فوٹو موٹو بھیجنا پڑے گا نا؟
آئی تھنک فوٹوز ٹریول ڈاکیومنٹس میں بھیجتے ہیں. جی, ایز فار ایز آئی کین ریممبر فوٹوز بھیجتے ہیں, مگر ڈاکیومنٹس نہیں ہوتے ہیں اس میں سوری, بی آر پی نہیں بھیجتے, اوریجنل بی آر پی نہیں بھیجتے اس میں.
اچھا جی, تھینک یو ویری مچ. ایک اور کویسچن ہے, اگر ڈیسیجن آ جائے آپ کا نا ہوم آفس کی طرف سے کہ ہم نے آپ کو اتنا اسٹیٹس, پہلے کورٹ کی طرف سے آپ کو ڈیسیجن آیا کہ آپ الاؤڈ ہے اپیل آپ کا ریفیوجی اسٹیٹس, پھر اس کے بعد بایو میٹرک بھی ہو جائے, پھر بایو میٹرک کے بعد آپ کا ہوم آفس ڈیسیجن بھیج دے کہ آپ کا یہ 5 ایئرز ویزا ہے, آپ کو کیا کرنا ہے کیا نہیں کرنا, یہ سب چیزیں بھیج تمہیں, اس کے بعد بی آر پی آپ کو کتنے بعد ملتی ہے؟
اگر ڈیسیجن مل گیا رائٹ کہ آپ کو ملنے والا ہے, پھر سم ٹائمز آپ کے پاس وہ فنگر پرنٹس کراتے ہیں نا. آئی تھنک آپ کے فنگر پرنٹس ہو گئے
وہاں ڈیسیجن فنگر پرنٹ پہلے کورٹ کا ڈیسیجن آیا تھا کہ آپ کا مطلب الاؤڈ ہے اپیل آپ کا, آپ رہ سکتے ادھر. پھر اس کے بعد ہوم آفس نے مجھے بولا کہ آپ فنگر پرنٹس کر لے, میں نے فنگر پرنٹس اپنا کر لیے.
نارملی فنگر پرنٹس کے بعد ود ان 2 to 4 weeks تو کارڈ آ جانا چاہیے.
اچھا, فنگر پرنٹس کے بعد ابھی مجھے 1 ماہ سے زیادہ ہو کے ابھی مجھے کل कल मुझे उसने डिसीजन भेजा था, सारा डिसीजन।
हाँ, वो
उसने
फिंगर
बोला था कि आपका अलाउड है, एक्सपायर डेट आपका यही है।
जी, आप वो फिंगरप्रिंट से काउंट करो ना, जब आपने जो फिंगरप्रिंट्स लिया तो इसके बाद विद इन 2 to 4 वीक्स में आ जाना चाहिए। कितना टाइम हुआ फिंगरप्रिंट्स के बाद?
उसको तो 1 मंथ से ज्यादा हो गया।
आ जाना, क्योंकि अभी बायोमेट्रिक कार्ड्स है ना, वो आ रहे हैं, इतना कोई डिले नहीं है अभी बायोमेट्रिक कार्ड्स में, वो प्रिंट हो रहे हैं।
अच्छा,
आ जाना चाहिए विद इन 2 to 4 वीक्स। पर नॉर्मली अगर प्रॉब्लम है ना, तो बेस्ट ऑप्शन आपके लिए यही है कि अगर आपको अर्जेंट चाहिए तो बेस्ट ऑप्शन आपके लिए यही है कि आप लोकल एमपी को कहो कि वो आपके लिए कोई ईमेल भेजे, उसको कोई कांटेक्ट करे। वो नॉर्मली अगर अर्जेंसी है ना, तो दैट्स नॉर्मली द मोस्ट इफेक्टिव वे।
अच्छा जी, सब केसेस में आप ये एमपी से, मतलब कोई भी केस आपको अगर डिले है तो एमपी से
हाँ,
जल्दी करवाने के लिए
जी, तो वो एमपी के थ्रू वो भेजो, क्योंकि वो लॉयर्स को तो वैसे भी इग्नोर ही करते हैं, वो जवाब नहीं देते क्विकली। तो जिस एमपी को इन्वॉल्व करो, उसका जो केस वर्कर है एमपी के ऑफिस में, वो सिर्फ उसको ईमेल कर देंगे कि लोग ये केस हो रहा है। तो एटलीस्ट इससे ये है कि वो कोई कोई जगह में स्टक हो गया है, वो भूल गए हैं, फाइल रह गई है, तो वो नहीं होगा। वो देख के होपफुली आपका केस आगे तो बढ़ाएंगे, वो उसको उसको फॉरवर्ड करेंगे। सो मे बी मुझको ये लगता है कि अगर
अच्छा जी, थैंक यू वेरी मच।
नो प्रॉब्लम है, थैंक यू वेरी मच, थैंक यू आपका कॉल के लिए, थैंक यू वेरी मच इंडीड। That was a call regarding how long it takes to obtain a biometric residence permit after the fingerprints are done. In my experience, within 2 to 4 weeks, hopefully it should arrive. Got a caller who's been waiting for a while. Let's go to our next call. Hello, Assalamu alaikum.
Hello?
Hello.
Yeah, I was just wanted to ask a question. I hold a refugee status,
Okay.
and it just expired on the 12th of December last month.
Okay.
But I applied for the leave to remain in November.
Okay.
Yeah, but waiting for the Home Office to hear from the Home Office. But I applied for the council house last week. I was made to understand I get the house, but they were insisting I should submit my resident permit.
Okay.
But which I told them is expired, so I have applied for the leave to remain. But they still insist. I send them a confirmation that I went for the biometric permit to take a biometric fingerprint. I send that confirmation and a letter from my job and also how to call it, my benefit that I'm entitled to public fund, which I'm having universal credit. I send them all those documents, but they tend to ignore. They say they're not accepting it. I need to give them the physical resident permit or the Home Office to confirm to me that I have applied for I have to apply for the leave to remain.
Yeah.
Or otherwise, they're not going to give me the house. They're going to give it to someone else.
Okay.
So I'm asking for advice for that.
My view would be this: that you speak to the council and say to them, you want to see their policy on this matter. On what basis are they saying that you must hold a current visa? As long as you've applied for indefinite leave to remain, or you've applied to extend your visa, your old conditions continue. So if you had refugee status, that continues until the application is decided. So I would say to them, what policy are you applying? What is the law that you are applying in terms of granting access to housing? So I want to look at what is it that you are considering my case against, what are the rules, what's the law policy that you are applying to my circumstances. That's the first thing I would do. The second thing you could do is contact your local councillor and ask your local councillor to intervene on your behalf. The local councillor may not be able to change their decision, but he or she would be able to get a decision for you more quickly. And by getting the local councillor involved, it could mean that they look at your application more carefully. They don't just fob you off, they look at it more carefully. So there are those two things I would do. Ask them, what policy, rule, law are you applying to my circumstances? Where does it say that I don't fit in when I've applied already in time? Secondly, get your local councillor involved. And that's what I would do. Hopefully that will resolve it. Thank you very much for your call.
Yeah.
Thank you very much.
Okay, thank you so much. Okay,
Thank you very
then.
much. Thank you. Jazakallah. Thank you. Call about access to housing. We get similar questions in relation to access to benefits when an application is in process. What is the position when there is an application which is pending? The problem is many organizations, when the original visa has expired and you are in that period where you've applied for the extension, you're waiting for a decision, many organizations will treat you as an overstayer. Now, in my view, that's incorrect, because whatever status you have, if you apply to extend or if you apply for indefinite leave to remain on time before your visa expires, then you remain completely legal and you are able to continue living in the United Kingdom on the same basis as you were living before. So if you had refugee status before, that status continues. If you were on a spouse visa before, that status continues as long as you applied on time. It's not the case that because your visa card says this is the expiry date, that the moment the expiry date passes, you become an overstayer or you become somebody with no status. If you apply in time, either before or on the day the visa expires, then your status simply continues. If you are receiving benefits, you continue to be entitled to benefits on the same terms as before. If you had the right to work, that entitlement continues after you apply for an extension on time. Your right to live in the United Kingdom, as long as you've applied on time, continues. You are not and you should not be classed as an overstayer. Now, you come across a lot of councils which say, you know what, this is what we need. In order to challenge that, the starting point always has to be, you say to them, what policy, document, what particular rules or what legislation are you applying to my circumstances? Once they are able to identify that, then look at whether you qualify under the scheme or not. If it's the case that for you to be eligible for something, you need to have a certain status, you shouldn't have lost it, etc., then my view, depending on the wording, my view is that if you have applied in time and you qualified before for that benefit, for that accommodation, if you qualified before and you've applied in time, my view is that the likelihood is you will qualify, you will continue to qualify as long as you have applied on time. So the starting point always is to ask for or get them to point to what is it, what rule, what legislation, what policy are they applying to your set of circumstances to see whether you can demonstrate that they are wrong. Now, as always, if it's an issue that you have with your local council and they are ignoring you, you're not getting anywhere, then my view always is that get your local councillor involved. Every ward has 3 councillors, so find out who your local councillors are. Get in touch with them. On the council website, there will be a way of contacting your local councillor. In my experience, councillors are generally very helpful. They will get involved. They'll call you back. They'll speak to you. There will be a way of getting in touch with your local councillor. Email them, give them a ring, ask them to intervene on your behalf. Now, obviously, they can't get you something that you are not entitled to. But what they can do is highlight your circumstances to the relevant officer within the council. And what they can do is put your representations, which maybe when you've done that, it's been ignored, put your representations to the officer within the council who's dealing with the matter, which may mean that it is taken more seriously. It may mean that your case is reviewed by a more senior officer within the council. So that's the way you challenge these kind of situations. You'll ask for the relevant law, relevant policy document to be pointed out, and you get your local councillor involved. Hopeful that if you do these 2 things, there should hopefully be a successful outcome for you. But it's a very common scenario. Now, we've had a number of other questions coming in on WhatsApp. Again, loads of questions on immigration law, which is fantastic. Just before the break, on the last occasion, I was looking at the visitor question. What I will do, we are unfortunately taking a break again, but when I do come back, I will look at the visitor question again straight after the break. We'll be back in the next couple of minutes. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. As always, to send me a message with your questions, with your queries, please do so by sending your message on the mobile number which is there at the bottom of the screen. So landline number is there for live calls to the studio here to speak to me live on air, and the mobile number is there for messages. And as always, we've had a number of messages coming in. Now, just before the break, I did look at a question on visitor visas. Unfortunately, I wasn't able to give you a full answer. Let me just very quickly read that question out, and then let's look at what the position is. The question is, my inquiry is regarding my mum's visa refusal. On the last two occasions, her visa has been refused based on her being alone in India. It's a visitor visa application which has been refused based on her mum, the mum being alone in India. The 4 children that she has are all in the United Kingdom. The Home Office believes that the mother won't go back to India. A very, very common scenario. There is a huge problem with visitor visas at the moment. It's always been the case, in my experience, that those who are young, those who are unmarried, those who may be studying, who don't have very strong links in the way the Home Office assesses strong links to their home country. It's always been the case that their applications are likely to be refused. Unfortunately, we've had a trend in the last, I would say, 5, 6, 7 years, whereby those applications which were previously being granted, even they are being refused. Certainly, when you go back 5, 6, 7 years, you found that applications for visit visas from elderly people, maybe in their 60s, in their 70s, were generally always granted. Nowadays, it's the norm. So we've had a complete change. It's the norm for those visit visas to be refused from elderly applicants. And that's the current trend. And the reason for refusing the application is also very similar in most of these cases. So for most elderly applicants, the Home Office seems to be taking the view that, firstly, it may be that you are now on your own because your partner's passed away. So you're on your own. You have no independent income. You're not employed anymore. You may not even have a pension. So you have no independent income of your own. You have no children under the age of 18, which is hardly surprising because these are elderly applicants in their 60s and 70s. Their children would have grown up. The children would have had children by now. So they're the reasons primarily that the Home Office use to refuse applications, that you're sort of on your own, you have no income of your own, your children have all grown up, or most of your family is in the United Kingdom, not in your home country. And because of that, they say your links to your home country are not strong. You don't have enough incentives to return to your home country. And therefore, the test in the immigration rules, which is whether the applicant intends to return to their home country, is not satisfied. So when they're looking at intention, does the applicant intend to return to their home country, when they're looking at intention, they are determining the applicant's intentions by looking at the applicant's circumstances. The fact that they may be on their own, they may have no income or very limited income, the fact that they don't have little children to look after. So they're looking at all those factors and then concluding that we believe you do not intend to return to your home country. Now, unfortunately, there isn't that much that you can do to counter that. But what I would say is this, that try and present, first of all, I think the key thing is make sure that your application, your supporting documents, as far as that's all concerned, first of all, that they cannot point to you exaggerating anything, being dishonest with them. So present the circumstances as they are, first of all. Don't exaggerate the circumstances there. Secondly, point out all the factors in the applicant's favor. And I'm sure it's already been done, but make sure that you don't simply submit supporting documents. You explain your case properly. So if it's the case that mum is on her own, but there are other close family members there, there may be a brother there, sister there, there may be some children there, prove by way of documentary evidence that that is the case. If mother has some kind of assets or income, prove that, demonstrate that. If there is a property that mum owns, that she lives in, demonstrate that she is the owner of that property. If you can get a valuation report, show that this is the value of the property that mum lives in. If there is land which is that they own, which is normal, what you normally come across, show the evidence of the land that they own, and if possible get a valuation report to show the financial circumstances. If there is income, document it properly in black and white. So, for example, if there is a property which is let out to tenants, show proof of ownership of that property, show that you've got a lease, show the income's going into the bank. So try your best to try and demonstrate that the requirements are met. I'll come back to this after I've taken the next call. Hello, assalamu alaikum.
Assalamu alaikum.
Ji wa alaikum salam. Ji bhai, thank you for calling.
Probably remember I phoned a couple of weeks ago
Right.
about applications
Right.
as a carer of a British citizen
Right.
under the Zambrano principle.
I remember.
And I've been waiting for around
A while.
7
yeah?
months.
Yeah.
7 months.
Yep.
Yeah, quite a while. I've checked on internet and I saw there is a case going on with the Zambrano principle, the Akinsonia.
Yeah.
And it says it's still on High Court.
Yeah.
They're waiting for the hearing date and stuff.
Yes.
My question is with my Zambrano application, my application was granted earlier,
Yeah.
and my application, my visa was valid until 30th of June 2021.
I understand.
I made the application for an extension. Either it will be granted as pre-settled status or settled status.
I understand.
My question is with this Akinsonia case,
No.
is it going to impact my application?
No,
or,
not yours, because it shouldn't affect you, because you were granted a Zambrano visa under the Home Office's own interpretation of the Zambrano rules as they existed before. So you were granted it. So you should be granted pre-settled status as a formality. Automatically, you should be granted it. Because you are not somebody trying to go into the Zambrano route. You are already in the Zambrano route. All you are doing is...
So in that case, sorry, can I ask you a question, please?
Sure.
So in that case, did I make a mistake putting the same Zambrano applications, or should I made an application, just the online applications as a EU pre-settled status or settled status?
No, I think for you, you had to use the paper form. Did you use the paper form to apply?
I used the paper form.
You see, what happened was most applications could be done online, but the Zambrano ones couldn't be done online. The Surinder Singh route couldn't be done online. There were some applications that couldn't be done online. So you had to apply for pre-settled status using their online form.
Okay. And I've just got one more question. If you don't mind, can I ask you the other question?
Of course you can.
I have my mom and my sister live in Bangladesh. Obviously, if my dad wants to bring my mom as a dependent of a British citizen,
Yeah.
he can. But the thing is that my mom doesn't want to come here and live here forever, or even because obviously she has got physical disabilities and stuff.
I understand.
Can my dad make an application, can my mom make an application to come here to see my dad as a visitor? Are they accepting any visitor application from Bangladesh, or normally how long it takes to
So anybody can apply for a visit visa, but what are the chances of mum being successful? I would say the chances are not very high of a visitor visa from a spouse to the United Kingdom being successful, because they just think you're just trying to get round the spouse.
No, but unfortunately, the people who work in Home Office, they don't have any. They don't have any sympathy, or they don't take the thing seriously. Why? Because I made the similar applications in 2017 when my dad was in critical care unit in hospital, while my dad was about to die. And then even on that time, they rejected my mom, saying that if my mom comes there, she's not going to spend her money.
Absolutely, absolutely. I mean, just this afternoon, I was speaking to a client who said, look, we need to make an emergency application for a brother to come to the United Kingdom because the other brother is in hospital in critical condition, about to pass away in the next week or so. I said, look, you can make the application, but the circumstances that your brother is in the UK, the Home Office will just look at that, and that is no guarantee that the visit visa will be granted. There is still a strong likelihood it's going to be refused. What can you do? That's the way it is. So in answer to your question, the visit visa for your mum being successful, I think is very low, unfortunately.
Yeah.
But brother, thank you very much for your call. Unfortunately,
so much.
We're taking a break, so I'm going to have to cut the call. But thank you, Jazakallah. I'm very grateful for your call. Visit visas, we were talking about that before. The chances, unfortunately, in my experience, of getting visas from India, Pakistan, Bangladesh are not very high. To me, it looks like the applicant's financial circumstances have to be pretty good before a visit visa will be granted. And I think that's really where we've ended up. They seem to be ignoring all the other factors, the compelling family reasons. It seems to be an assessment of the applicant's financial circumstances. We're going to be taking a short break. Inshallah, when we come back, we can look at this in greater detail, especially this problem with visit visas and what you can do to make your application stronger. We'll be back in the next couple of minutes, inshallah. See you then. Assalamu alaikum. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. As always, to send me a message, you can send that message on the mobile number which also appears at the bottom of the screen. Just before the break, we were looking at the particular problems that applicants face when making visitor applications, and we have all heard of stories where applications have been made by elderly people, but those applications have been refused on the basis that the Home Office takes the view that they don't accept, they don't believe that the applicant will return to their home country. And I was explaining before we took the last call, that there are certain things that you can do to try and make the application stronger, make a credible application, don't exaggerate your circumstances, make sure that they can't say you're being dishonest anywhere, and explain your circumstances as fully as possible, explaining your family circumstances, explaining your financial circumstances, explaining your income, explaining your reason for the visit. So I think it's one of those where a bit of work does need to be done. And I think it's probably a more difficult application to do if you're doing it properly than sponsoring a husband or wife to come to the United Kingdom. I think visitor applications are particularly difficult. There's a lot of work that needs to be done. And if you do a rushed job, don't really pay attention, then it just decreases the chances of the application being successful. So I think there's a fair amount of work that needs to be put in order to make a successful application. And even after doing all that, there is no guarantee that the application will be successful. And I think the particular problem is in terms of using lawyers to do visitor applications. I think the particular problem is that the lawyer can't obviously guarantee that the outcome will be a good one, that the visa will be granted. And so you do find that sometimes if you're paying fees, whether it's £500-600, whether it's £1,000, and after doing everything that properly, lawyer doing everything properly, if the application is refused, you might feel that you've lost a lot of money, and therefore there's a slight reluctance, understandably, on the part of sponsors who are in the UK to spend this kind of money when the outcome is not guaranteed. To spend £500-600, £1,000 when the chances are only realistically 50-50 in getting a visa. So you tend to find that sometimes you cut corners yourself, or a proper thorough application isn't submitted because you can't really afford to spend so much money. You can't get it done professionally. Sure, the application that goes in, it's not up to standard, and that makes it even more likely that your application will be unsuccessful. So from a 50-50 case, your percentage chances drops because there's gaps in the application. The right evidence hasn't been submitted. The explanations that need to be submitted haven't been submitted. So it is very tricky to make a successful visitor application at the moment. Okay, we've had a number of other questions coming in. Let's have a look at the next question that's come in. Quite a long question. And our viewer says, Assalamu alaikum. My question is on behalf of my friend. She met a man and got married. Pre-marriage and during the first few years, he led her to believe he was extremely caring and he loved her. He then arrived in the United Kingdom without any legal documentation. Following the marriage, they began the process of obtaining a proper visa for him. At present, he's received his first grant of leave. Will be waiting for the next one, and in due course, he will be eligible for indefinite leave to remain. Now, my friend has realized that she's been misled and she's been used for a British passport. They have a child together. Child is less than 3 months old. He neglects both her and the child. His sole concern is money. Bills and other utility bills are covered by my friend, not by him. She feels extremely neglected and isolated and does not know what to do. Is there any way he can be prevented from getting a British passport? Okay, sad set of circumstances. Now, what I'm unclear about is that initially you're saying here that he's got his first seal of approval. I'm not sure what that means, but look, we need to know where he is in the visa process. An overstayer who is in the United Kingdom would normally be placed on the 10-year route to settlement, so whereby they would get indefinite leave to remain after 10 years. So we don't know where this person is. Is it the case that they are on this 10-year route to settlement? Or is it the case that they've got indefinite already and they are simply looking at making the next application, which is applying for British nationality? So it's unclear where we are. But let me break it down in quite simple terms. That if you have a situation where the husband has been granted indefinite leave to remain, permanent status, then there isn't much that the wife can do in the circumstances, because he already has the right to live in the United Kingdom on a permanent basis. Once he gets that, he is no longer dependent on the wife. So his status is no longer connected, is no longer dependent on the wife or the child. He has indefinite leave to remain in his own right. So in those circumstances, it is very difficult to do anything to cancel that indefinite leave to remain. So the key starting point is this: what is his status? If he has indefinite leave to remain, there is really nothing that can be done. If he's simply now applying for or waiting for British nationality, in most cases, even if the British wife objects to the husband obtaining British nationality or doesn't give her approval, in most cases, the husband just has to wait 1 year after obtaining indefinite leave, and then he would be eligible to apply for British nationality in his own right. So, if we're in a situation where the husband has indefinite leave, there is very little that a wife can do to cancel his visa or to prevent him from ultimately obtaining British nationality. If, on the other hand, the husband hasn't obtained indefinite leave to remain, he has limited leave to remain, whether on this 10-year route or some other route, then there may be something that the wife can do if their relationship has broken down. And what I would normally advise clients, that if your relationship has broken down and there is no likelihood of reconciliation, you getting back together, you're given things time, and you are definitely sure, you are 100% sure that this relationship has now come to an end, then you could, if you wanted to, inform the Home Office of the breakdown of the relationship. In such a situation, the Home Office can take the step of curtailing the visa that the husband has. If there are no children, it's fairly straightforward. The visa would be curtailed. That would be normally the end of the matter. The husband would have to, what the husband would normally do is then try and get into some other route to remain in the United Kingdom. So, if the husband does not have indefinite leave to remain, he simply has limited leave to remain, whether on the 10-year route or any other route, and the relationship has broken down, then potentially the Home Office will curtail the visa where there are no children. The problem here for you, if I can put it that way, is that there are children here, or there is certainly a child here who, from the question, appears to be less than 3 months old. Potentially, the husband can, even if you as the wife, you curtail his visa or you try to curtail his visa, potentially the husband can make an application to remain in the United Kingdom based on the child, based on contact with the child, based on access to the child. Now, you may object for whatever reason. You may say to the Home Office, look, our relationship has broken down. There is a child, but the husband has no contact. What you need to be aware of is a properly represented person would not only seek the advice of an immigration law expert, would probably seek the advice of a family lawyer, and in normal cases, the husband would be advised that, look, if the wife is preventing you from having access to the child, having contact with the child, you can make an application to the court, follow the court process. If you get the contact order for contact with the child, based on that contact, you are likely to be granted leave to remain in the United Kingdom. Not on the basis of your wife, not on the basis of your relationship, none of that, on the basis that you are having contact, you are seeing your child. So, this isn't a straightforward situation. Relationship breakdowns are unfortunately all very common, happens all the time. If your partner has indefinite leave to remain, there isn't going to be much realistically that you can do. If your partner has limited leave to remain and there are children, again, you could, if the relationship has broken down, inform the Home Office that this is the case, curtail his visa. But there would normally be an option open to the husband to apply for leave to remain in the United Kingdom based on the child, based on contact with the child. So that's basically where we are in this particular scenario. I completely understand, based on the circumstances set out, a very lengthy circumstances set out in a very lengthy message, how difficult it has been, how things haven't worked out. But there are really, in terms of options for the aggrieved party, options are sometimes quite limited when there are children involved. But thank you very much for your message. I hope that fully answers your question. I know I've taken it towards the very end of the show. If you're not sure about the answer that I've given, or you want to look at this in greater detail, then please do come back to me. I know we've come to the end of the show today, but I will be back live on air next week on Tuesday at 8 o'clock, so I can guide you, assist you more in relation to this complex question that you've raised. So we've had fantastic questions coming in today on visit visas, on spouse applications, and also on this particular topic about marriages breaking down and how visas can be curtailed. Unfortunate set of circumstances. It happens all the time. Sometimes spouses can do something to try and curtail a husband's visa. Sometimes their hands are completely tied in these circumstances. All I would say is, look, if you do find yourself in this unfortunate situation, you do take professional legal advice. A lawyer who's used to dealing with these matters will be able to guide you properly, not only in relation to the immigration law aspects, but also in relation to any family law aspects of this particular set of circumstances that you find yourself in. That brings us to the end of the show. Inshallah, we'll be back next week at the same time. Inshallah, see you then. Assalamu alaikum.